You heard me give the recitation of the procedure here with the attorney beforehand. You each will get 15 minutes to present your argument. The appellant may reserve up to 5 minutes. Now, I know there's a cross appeal here. The cross appellant doesn't get a reservation time. The cross appellant just has to deal with the response to the appellant as well as its cross appeal. And so that's the way it works. This is not a case where we have to really worry about victims or children, but we always like to remind everybody that it is being videotaped and we don't use any victims' names or any children's names, any minors. Please stand behind the podium and keep your voice up. I didn't realize that our mics weren't on, so I now can really amplify my voice, I guess, now for you guys. So, but at any rate, we each have, like I said, 15 minutes. And just as the appellant, let me know how much time you would reserve. Thank you. You may proceed.
May it please the court. My name is Amanda Leffler. I'm here with my partner, Wes Lambert, on behalf of the appellant Goodrich Corporation, and I would like to reserve 3 minutes, please, for my review. I'd like to start with Goodrich's appeal. The sole question before you today is whether or not Goodrich's interpretation of the commercial union policies is a reasonable one. In reality, it is not only a reasonable one, Goodrich's interpretation is the most reasonable one. And this is true for multiple reasons. The text of the policies themselves, 2 Ohio appellate courts, commercial union, the issuer of these policies in another case, and multiple reasonable people affiliated or associated with the issuer commercial union all agree with Goodrich's view that the policy language can be read, and in fact should be read, to provide for annualized per occurrence limits. This court is well aware of the legal standard that is to be applied here. This is black letter Ohio law adopted by the Ohio Supreme Court in many cases. If Goodrich's interpretation is a reasonable one, it is the interpretation that must prevail. Under these circumstances, there's really no doubt that Goodrich's interpretation is a reasonable and the most reasonable one, and the trial court's determination to the contrary was an error. I'd like to start with the text of the policies themselves. The trial court held that absent a modifier expressly stating that the per occurrence limits would apply per year, they'd apply by default per term. And that's wrong for several reasons. First, it's wrong as a matter of basic grammar. You can add...
Was it per term or per occurrence? So I think we're really turning on the word occurrence here.
I think we are. I think that's exactly right. It is each occurrence, and you could say each occurrence per year, and that wouldn't make the phrase contradictory.
But doesn't the yearly amount just pertain to the paying the policy to get this amount per occurrence per year? Based on the plain language.
Based on the plain language, and I think it's useful to look at the 2 determinations from the first district to help explain Goodrich's view, and my view, reasonable view, of how these policies can be interpreted. Because the modifier per term or per year is not included, you can read it either way, and it doesn't make the sentence confusing. It's that lack of the modifier alone. Each occurrence, each can mean one, yes it can, but each occurrence each year or each occurrence each policy term doesn't really answer the question.
Is there any dispute here that this case is based on one occurrence?
No, there's no dispute that there is a single occurrence in connection with this case. That is correct. The question is solely whether the policies can reasonably be read to provide annual limits for that single occurrence. From our perspective, the text absolutely results in a conclusion that they can be read as annualized per occurrence limits. Not only can the text be read that way, but the trial court's interpretation that allowed an assumption of a default where the insured should get less coverage, that's completely contradictory contradictory to decades of Ohio law. And you can't read the language, the very cryptic limits language alone. You have to read it in context with the fact, and Judge Lansker, perhaps this is what you were referring to as well, that the premiums were going to be paid separately and annually over a 3-year period in order for the coverage to continue. And I think I want to point out too, and just focus on the second policy for a moment, because the trial court did something a little odd. She implicitly acknowledged that the second policy was ambiguous. And she had to have done that because in interpreting both policies, she considered language that was only found in the third policy, not found in the second policy. So she looked at language from that third policy that was not even in existence at the time the second policy was entered, and considered only that extrinsic evidence, and that was an error. I'd like to focus for a moment on that case law that we were talking about a moment ago. Goodrich's interpretation is also reasonable because multiple courts and commercial union itself have held that this type of language can be read as Goodrich believes it can be read. In the Cincinnati Insurance Company versus Ace case, the insurer made the exact same argument that Nico is making here, that absent a specific language that the policy would have, that the limits would apply per year, the default would be that they would apply per term. The court there said exactly what we say. Because the word is reasonably susceptible to either modifier, per year or per policy, it's semantically ambiguous. The William Powell court held very similarly that the absence of that limiting modifier is what makes the word, and in that case aggregates were an issue, what makes the word aggregate ambiguous as to how the limits should be applied. These cases are directly on point. Now, Nico attempts to distinguish them, but it cannot distinguish that the exact grammatical analysis being performed by Goodrich here is the grammatical analysis that was performed by 2 panels in the first district under Ohio law. I think what I personally find one of the most compelling pieces of evidence is the commercial union versus Swiss Re case. And just as a reminder, commercial union, of course, is the issuer of these policies. This was a case in which commercial union argued and submitted evidence that its policy language, that the phrase each occurrence was fundamentally ambiguous. When it was to commercial union's own benefit to argue that there was ambiguity in that language so that they could recover reinsurance proceeds, they made that argument. But here, Nico wants you to believe that no reasonable person could have possibly understood that cryptic language to mean that the per occurrence limits would be annualized. What better evidence that a reasonable person could understand that this policy language could be annualized, that per occurrence limits could be annualized, than the fact that the insurer that issued the policies said so in another case. We think these cases, frankly, are dispositive of the issue before the court. It is obviously reasonable for Goodrich to have reached the same conclusion as 2 Ohio courts. It is obviously reasonable for Goodrich to have reached the same conclusion that commercial union itself advocated for in another case.
Counsel?
Yes.
Counsel, how do we consider what they stipulated to or advocated in another case? How is that binding on them in this case? How can we use it?
So I don't know that I would say that it's binding on them as much as I would say it is evidence of what I have to prove, which is that our interpretation is a reasonable interpretation. It's reasonable because commercial union itself said it was a reasonable interpretation. I wouldn't necessarily say that commercial union is bound by that. It's all in the case. It's all in the Swiss Re case.
And I think I understand what you're saying, but I guess I'm still trying to figure out how we can use that in summary judgment proceeding.
So,
I mean, we can look at a case, obviously from another district for, their reasoning and so forth, and to help our analysis, because obviously it's not binding on us, but we can do that. But what somebody admits or argues in another case, I'm not sure how that would be necessarily relevant to our analysis here.
So I think you can consider that and anything else under a couple of standards. First is the context always has to be considered. contract. This court's held that, the Supreme Court's held that, we're always going to be looking at context. Second, the policy language on its face is ambiguous, and that's what we have from the first district. The policy language is on its face ambiguous, thus you can consider things beyond the contract to understand its meaning. Third, from our perspective, again, that evidence, the admissions, and it's arguments, it's a slightly different case when we're talking about reinsurance. The point, though, is that commercial union in publicly filed materials argued and advocated for a position that now its guarantor is saying is inherently unreasonable. So from our perspective, again, you absolutely can consider, this case law and these things that were stated in another case.
Do you mean you can consider it if the court finds that the contract's ambiguous? Because we didn't get that far in my reading of the court's entry. The court found, as a matter of law, this contract is unambiguous. And I understand the argument that we have to look at the contract as a whole, and there's other things, and I understand the argument tacitly found that the second policy was ambiguous. But as it relates to all these other things farther down the line, don't we just stop when we look and see whether or not the court erred in finding that it was unambiguous?
So it's kind of a chicken and an egg, isn't it, a little bit? And I can tell you that my head and multiple people in my office's head have, borderline exploded thinking about this. But here's the bottom line of how we look at it. I don't believe this court is constrained at what it can consider in its judgment to determine whether language on a page is ambiguous or not. That's, as a matter of law, you get to make that determination. I can't use, I acknowledge, I can't use parole evidence to establish an ambiguity. But I don't think you are constrained from looking at other cases. And in fact, frankly, the Ohio Supreme Court would require ambiguity to be found where there are cases that interpret the language two different ways. So I think you can look at this information, this evidence in that context as well. These are record decisions of other courts, and I think the court has absolute authority to review those in determining, when I look at this language and I look at all of the things on this page, is this ambiguous? Could this reasonably possibly be read as Goodrich has read it? And the answer when you look at those things, frankly, just looking at the page, is yes. It's yes.
And you have like 30 seconds.
I
before you
know,
start.
I know. How about if I reserve 3 minutes and 30 seconds?
That's fine, thank you.
Good morning.
Good morning.
May it please the court. I'm Patricia Santel with the firm of White & Williams, along with my local counsel, Daniel Richards, from the firm of Western Hurd, representing the cross appellant and appellee NICO. I would like to reserve 5 minutes for rebuttal. This court,
There's no rebuttal, remember? That's what I was explaining from the start. There's no rebuttal, that's what I was explaining from the start.
as the appellee.
Yeah, no, you have a cross appeal, right? Okay, with the cross appeal, you have to present everything here in your appellee's time of 15 minutes. We're gonna go back and forth, even though we just look at it as the primary appeal, and that's the appellant, and that's the appellant that gets the rebuttal time, and that's it.
Okay, thank you for clarifying that.
Sorry about that.
This court should affirm the trial court's grant of summary judgment in favor of NICO. The trial court's ruling was consistent with well-established principles of Ohio law and the overwhelming majority of cases around the country. The policies provide, quote, the company agrees to pay up to the limit for each occurrence, close quote. The total limit for each occurrence under the 3 policies issued to Goodrich was $95 million. The company has paid Goodrich $95 million for what the parties agree is a single occurrence. Goodrich received the benefit of its bargain years ago, but it is now seeking more than 3 times what it bargained for under the 2 multi-year policies.
Counselor, you started your argument with saying that the overwhelming majority of cases around the country have found that this term is not ambiguous. But there are some that have said it's ambiguous. So what is your reply to the appellant that says if some cases find something ambiguous and some cases find the same language non-ambiguous, doesn't that mean that in essence it is ambiguous and that we should interpret it that way?
Well, with all due respect to the appellant, there is not a single court in this country that has found that a multi-year policy provides annual per occurrence limits in the absence of annualization language. So I would respectfully disagree that there is any split in authority. The only cases that Goodrich is citing are either reinsurance disputes, where a reinsurer followed the fortunes of its underlying company in a settlement context, or the two Ohio First District cases, which did not concern occurrence limits. They concerned aggregate limits, which are generally in the industry annualized. Goodrich is asking this court to read words into the policies that are simply not there. NICO is asking the court to apply the policies as they were written. This is consistent with Ohio law. When the terms of the policy are unambiguous, they must be applied as a matter of law. The Supreme Court said in Westfield versus Galatas, the presumption is that the intent of the parties, quote, is reflected in the language used in the policy, close quote. The court should look no further than that. The court does not need to look beyond the policies because they're not ambiguous. They are not subject or susceptible to more than one reasonable interpretation because the words are clear. Again, quote, the company agrees to pay up to the limit for each occurrence, close quote. Goodrich's alternative interpretation is simply not reasonable because it is not based on the policy language. The Ohio Supreme Court held in Sauer versus Cruz, quote, a court cannot create an ambiguity in a contract where there is none, close quote. Nor can an ambiguity be, quote, created by giving a strained or unnatural meaning to phrases, close quote. Yeager versus Pacific Mutual Life. Anything can be manipulated into ambiguity if you torture it enough, which is also contrary to Ohio law. Again, to paraphrase the Ohio Supreme Court, this is Gamalka versus State Auto, the court should not indulge in enlarging the contract to reflect something other than what the parties agreed to, nor read into the contract a meaning not placed there. There is no need to add words, such as per policy term or triannually, to make the language in these policies unambiguous. That would be extraneous. It is sufficient that the policies provide for a single limit for each occurrence. We've cited almost 20 cases which agreed with the trial court's ruling here that in the absence of annualization language, there is simply no justification to provide more insurance coverage than what the insured bargained for, which is a single limit for each occurrence. The two Ohio First District court decisions relied upon by Goodrich are distinguishable, and they're not binding on this court. They did not concern whether multi-year policies had occurrence limits. In fact, they concerned asbestos products claims which involved multiple occurrences, and therefore aggregate limits, which, as I said a moment ago, are generally annualized in multi-year policies. The situation presented here is completely inapposite. The courts that have considered the question of term versus annual occurrence limits have also rejected arguments such as Goodrich is making here regarding premiums. What Goodrich purchased was a 3-year policy. It got the benefit of locking a premium in for 3 years, and it got 3 years of coverage with a separate limit for each occurrence. So here there was a single occurrence, which implicated all 3 years, so Goodrich received a single limit. If there were other occurrences, Goodrich would have been entitled to a separate limit for each one of them, as long as they implicated one of the years of the policy.
So the 3 years, as we talked about, was $30,000 per year. Is that correct?
It was a $90,000 premium that then was billed in $30,000 installments. But the premium was determined upfront.
Right. And the original contract, or the original insurance agreement, the previous one was $20,000 for 1 year.
Or $25,000.
Oh, I'm sorry, okay, $25,000.
Correct.
So, I mean, obviously you can make a bad deal, but that doesn't seem to make sense.
Well, they bought multiple years of coverage. They bought 2 3-year policies. In fact, they did the same thing with the underlying insurer, Amico. They bought a 6-year policy from Amico and accepted one limit from Amico for this same occurrence. And, which is, you know, I was going to get to this in a moment, but it's interesting that Goodrich is trying to say that my client had a different understanding of course of conduct. In fact, I would turn it around and say it was Goodrich that, in reaching a settlement with Amico, that demonstrated a course of conduct. Of course, our position is that the court doesn't have to look at anything outside the policy. But if you were to look at the record, I think you would see that Goodrich's course of conduct in settling with the underlying primary insurer, Amico, by taking one limit for the same occurrence for a 6-year policy is probative, if not binding on them.
So counsel, if in year 1 of that $90,000 policy, there was an occurrence and they filed a claim, but then in year 2, they failed to pay the installment of the $30,000, they haven't paid the full 90, then do they not have coverage for that occurrence that occurred in the first year of coverage that they paid for?
If they paid the premium for the first year, they would be entitled to coverage for any occurrences that triggered that year of coverage. If the occurrence only triggered the second year of coverage, and they had not paid the installment that year, the policy would have been terminated and would no longer have been in effect.
So it doesn't sound like it's a 90-year a $90,000 contract. It sounds like it's $30,000 contract.
No, it was one $90,000 premium for 3 years. Your question assumed that they failed to pay the premium the second year, so the policy would have been canceled at that point. It would no longer be in effect.
If I may to jump in here, I apologize, because I think that's an excellent question of Judge Hensel's. And that is, so I think what Judge Hensel is saying, how can you say it's a 3-year policy, but you don't pay the full 3-year premium, which is $90,000, okay, the contract price, but yet you're going to cover things in a piecemeal manner based on the year?
I would respectfully disagree that it would be in a piecemeal manner. Let's pretend it's a 1-year policy. If Goodrich or any policyholder fails to pay the premium when it's due, the policy will be canceled at that point. So again, respectfully, I understand the question, but to me, it's not the same as creating a separate annual limit for an occurrence in a multi-year policy.
Well, but the position could be taken by the insurer, could it not, that even though this occurrence, or, that this, whatever happened for the occurrence to happen, that it was in the first year, and 5 years down the road, they make a claim on that, I would see where an insurer could say, well, yeah, but you never paid for the 3 years, so you can't just pick and choose which ones we're going to cover.
Well, again, the policy term, it would only cover occurrences that triggered the term of the policy. So if in the hypothetical, the policy has been terminated sooner and the occurrence triggers a later year that's not covered, it's not covered. Of course, this is not what happened here because the policy remained in effect, both of the policies. In fact, the issuing company insured Goodrich for 7 years. So it's a hypothetical. I understand your questioning, but from my perspective, it's not relevant to the issue of whether there's more than one occurrence or whether there's annual occurrences. It's just relevant to the term of the policy.
And I understand that. What concerns me is that intervening settlement agreement on a reservation of what's left to be argued. It's like I'm trying to, I don't disagree with what you're saying, okay? I'm just trying to understand the argument. Because we have this intervening settlement agreement that talks about what's reserved. And I just need to understand that the language of the contract was either ambiguous or unambiguous with what happened prior to where we are at the end of this
Yes,
controversy.
Yes, and in the earlier case in Summit County, the insurers, including my client's issuing company, had actually filed a motion in limine to get relief or ruling from the trial court on whether the multi-year policies had term or annual limits, and that issue was never ruled upon. It was not necessary to be resolved in the context of that case. And when the parties were negotiating the settlement, obviously they were identifying issues that they didn't agree upon. So that was one of the issues that was reserved. Frankly, I was not involved. My colleague may have been. At the time of the settlement agreement, it's possible that the parties never envisioned that they would have to spend more or need more than the $95 million in limits that the issuing company paid. And so, while it is consistent with well-settled Ohio law for the court to not consider extrinsic evidence, the type of evidence that Goodrich is relying upon in order to find an ambiguity in a policy. In Schifrin versus Forest City, the Supreme Court held extrinsic evidence cannot be considered in an effort to demonstrate an ambiguity. And I think Goodrich's counsel conceded that point, but they're asking the court to consider other cases and other so-called extrinsic evidence to find that their interpretation is a reasonable one. And we respectfully disagree that their interpretation is a reasonable one. The language of the policy supports our position. The courts across the country in resolving this issue as recently as the day after we filed our last brief, a case was decided in Wisconsin, which we filed with the court, have agreed that you don't need to add the extraneous language to make these policies clear. So we would respectfully ask the court to not look outside the policies, nor should the court consider Goodrich's expectations.
And ma'am, you're out
Oh.
of time, so you just need to sum up, that's all.
Sure. So while the record would support in our minds that Goodrich didn't have a reasonable expectation that these policies would be read to have annual limits, Ohio law does not allow the expectations of the policyholder to be used in interpreting the language. And in closing, the case begins and ends with the policies. We did have a contingent cross appeal. If this court does not need to reach that, if they affirm, if you decide to affirm the trial court, and in the interest of time, obviously we will rest on our papers unless if you have questions about our cross appeal.
Thank you.
Thank you.
You may proceed.
Thank you. I'd like to start by addressing the comment that there's no split in authority. I think that comment misses the point. The two Ohio cases that we've identified in our brief are directly on point. The analysis is exactly the same that we are asking this court to perform here. There are no other cases interpreting Ohio law except for one, a federal district court case out of Pennsylvania that predates the two cases from the first district. The other thing is that none of the cases that are relied upon by NICO in its brief have any of the context that we have here. And again, this is not us trying to create an ambiguity or trying to use parole evidence to create an ambiguity. This court must and should consider the context under which these contracts were entered. Extrinsic evidence is permitted for that purpose. It's not permitted under the parole evidence rule. It is not permitted to contradict the language of the policy or to create an ambiguity in the first place, but you are allowed to consider context. This court's held that, the Supreme Court has held that. And the context here, I think, is important. We have that first policy premium benchmark, and some of the questions you asked my opponent related to this. That first policy premium of $25,000, makes really no sense for Goodrich to have paid 2/3 more for something, for the same thing. No reasonable policyholder would pay more for less. And again, because the lens through which we're viewing this question is whether or not Goodrich could reasonably have understood the policy to provide annual per occurrence limits, the answer to that question is yes, and that's part of the reason why. The other contextual piece here that we haven't talked very much about today is the reinsurance analysis. This policy wasn't even drafted, and that's undisputed, by a commercial union. It was drafted by the reinsurers, who themselves were treating these policies as having annualized per occurrence limits. Those contextual facts are absolutely proper for you to consider when you are putting yourself in the shoes of the parties at the time that they entered into this contract. I wanted to very briefly touch on the comments regarding Amico and say only this. It is absolutely untrue that we took one limit for that 6-year policy. That was a negotiated settlement, which frankly, under well-established Ohio law and rules, is not admissible to be considered under any circumstances. But even if you were going to consider it, it's not probative. Our settlement, which was a formula and actually resulted in more than a $20 million per occurrence limit payment, is not probative of what commercial unions' policy limits are. So that's not something that this court should consider at all. I'll touch very, very briefly on, I know we didn't get a chance to talk about it much here today, but about the cross appeal, because I wanted to make this point. At its core, what NICO is asserting is that because it has essentially a defense. Okay, this judgment was entered, Judge Carr, I actually think you were on the panel that affirmed that judgment in 2008. This judgment was entered in 2007, was affirmed on appeal, and Lamorak paid on that judgment for years. It clearly is an obligation that existed at the time and continues to exist. What NICO is essentially asserting is that it has a defense. It has a defense of satisfaction.
You're out of time, you need to just.
Of course. I will say only that if every guarantor could assert a defense, it eliminates the existence of the obligation in the first place. That would be an issue for commercial contracting in the state of Ohio. With that, Your Honor, we respectfully request that the trial court's determination be affirmed as to the press appeal and reversed as to Goodrich's appeal. Thank you very much for your time.
Thank you. Thanks to both sides for your presentations and your appearance here in court today. We appreciate that, and we will take the matter under advisement and will issue a written opinion that will be sent to all sides. And again, as I told the argument, the people before you, you can look on the Ohio Supreme Court website where we release electronically. That might, if you're very anxious, you can see that just a little bit quicker. Thank you so much.
Thank you.
Enjoy the rest of your day.
Thank you.